Hello, everybody. Welcome. I'm hoping that other people will be filing in. We're supposed to be having 27 or so people tonight, so we'll take it step by step. As usual, I start off by sharing my screen, and so we can just meet and greet. We welcome you to Eureka Meet. It's our first meeting of the month, as it were. We meet on the first, second, and third Wednesday. And this is our Eureka Meet, which is on the second Wednesday of the month. Today, as you see, Anthony van Zantwijk. Welcome, Anthony. Anthony's a partner at S&Z. He co-founded the company. He's a patent attorney. He specializes in IP commercialization, tax, and valuation. He's been an expert witness in 4 IP transfer, pricing, and valuation court cases. Sibanda and Zantwijk files around about 500 South African patents per month. So I guess we can listen to what Anthony's got to say when he actually introduces his subject, which is how to save time and money by being prepared before you see your patent attorney. And then we will look particularly at how best to use your PPA. I'd like to go over our meeting format. Our speaker does take over, so please in Q&A get your questions, or you can be ready to ask them live. Say hello to us in chat as well, please. Tell us who you are and where you're from. Because it's a Zoom meeting, I always ask you to keep your cameras on, please. It's really off-putting to look at a sea of black and white names. Please mute yourselves as usual, so that we avoid outside noises. Advice always, seek professional advice on your IP questions. Notice that our disclaimers are in place. It'll be your decision to use whatever you may learn at our meetings. We all know that we are recording tonight. Electricity rules, okay, I always just say that to be careful. But our co-host tonight is Janine Preston from SA Commuter Radio. And today I always choose a quote for the individual speaker of the evening. And the one I chose for you is Nikola Tesla. I don't care that they stole my idea. I care that they don't have any of their own. I don't know how particular that is to you, but maybe Nikola Tesla is the kind of person who could have said that. I think most other people would be very careful, and they would not like people to steal their ideas. So your services are the kinds of services that we really need. I'd like to ask you please to visit the website for details of our upcoming meetings. I didn't have them quite confirmed today. So our next meeting, 14 September, and the one after that, 21 September. I'm thrilled to let you know, people. Stephen Key will be in Johannesburg, 25th of October. I've got the yes, we know, because a couple of people that I said that to, they said, no, never. And I said, yeah, we know, it's really a very fantastic thing. So please, you are going to be invited to join us for lunch, or there'll be an online webinar, obviously, for our international market. Another very exciting event that we're looking at the moment is our design competition for kids 4 to 16. You need to design a toy or a game or a method or a tool that makes learning fun or learning useful or learning enjoyable, shall we say, at school. But you need to use plastic, repurpose plastic, reuse plastic, find a different way of using plastic so that we are up against, so are not up against the plastic scourge as we actually understand it. This competition has been sponsored largely by Safripol. We've got our pitch to the panel coming up on the 20th of August. And of course, our website, please, www.iii.org.za. We're always working on the website. So we hope that you'll find something there that will suit you. And without too much more ado, Anthony, I'd like to hand over to you and to say welcome again. And thank you very much.
Thank you. All right, let me just try share my screen. Let me know if it's not.
Yeah, it's fine, thank you.
Is that good? Should I get
Very
rid of
good.
this thing on the side, or can you see this thing on the
No,
side?
it's very nicely centered.
Perfect. Okay, super. All right, so we're going to, now the aim here is to reduce the time, reduce the cost when you see patent attorneys, even not to see patent attorneys, if even be. Okay, because there's a lot you can do yourself in preparation for seeing a patent attorney. There's a lot you can do yourself even without seeing a patent attorney. Now we get a lot of phone calls from inventors, and a lot of inventors, of course, say, "Now I need to patent my brand. I need to patent the new shape of something." Everyone always talks about patents. A majority of the time, patent is actually not what they need to go for. Majority of the time, it's something else. It's either the design registration or it's the trademark. I mean, when we used to do a lot of work for inventors and actually draft a lot of patents for them, I mean, now we file a lot of patents, but it's mainly for foreigners filing into South Africa. But when we did used to file a lot of patents, I mean, we filed about half, well, we were the second biggest filer of provisional patents. And, you know, more than 90% of inventors who actually had something, we never patented anything for them. In other words, 90% of inventors who called us, who clearly had something potentially patentable, we never ended up filing a patent. The other most of inventors, they clearly, it was nothing patentable in the beginning, so they're not in the 90%. But 90% of inventors who actually, on the face of it, had an invention that potentially was patentable, we never, ever filed a patent for them. The reason is the search completely knocks it out. So, I mean, we'll have a look at it, but basically the first thing you really do need to do if you ever see a patent attorney, before you do, just do a search and we'll discuss what you should be focusing on in the search. It will save you so much money. The reason is, I mean, we refused as a firm ever to file a patent without first doing a search. We absolutely refused to do it. We didn't want to waste your time, your money, but more actually, truthfully, we didn't want to waste our time drafting a patent that was rubbish. However, we were the only firm in South Africa that took that line. Absolutely no other firm in South Africa even suggests you do a search. Most of them, they say, first get your patent in place, and then we'll see what happens. We're going to get a search ultimately when we file international patents anyway, and we'll get a search done basically in 16 months' time. Yeah, but in 16 months' time, you've just spent a hell of a lot of money, easily a good 80,000 Rand, only to find out that you either had nothing to start off with, or you were focusing on one aspect of your invention, but you should have been focused on another aspect of your invention you thought was secondary, but that was actually the only patentable feature of it. So do not waste money going to a patent attorney without first doing a search. So what most people do, they come up with the idea, they think they become spreadsheet billionaires overnight. They rush off to their patent attorney's office and they think they're going to patent it and make money as soon as it's filed. Now, no one, that really doesn't happen. You've got to do a lot more than that. The patent is only step one. We're not going to discuss that, but commercializing it is a tough one. But before you go to your patent attorney, there's a lot you should be doing. From the idea, generally, think about all the other ways you can make it. You're going to rush off to a patent attorney and show him your idea. He's going to try to patent your idea. He's not going to think too hard. He's going to put a bit of thought into how else to do it. He's going to ask you, what if I did this way? Would that be a problem? He wants a patent to cover your idea as broadly as possible. But you're the person who has got a far greater insight into your idea and how potentially you could make it in other ways. So don't just go to the patent attorney with your specific idea. Spend a bit of time thinking how else your competitors would want to make it, how alternatively, where it would still be commercially viable, Because when you speak to your patent attorney, you want to put your idea down and then put the other ways of doing it so that he has so he knows what the patent claim needs to cover. That your expectations that your patent claim covers this and all of those. But still don't go to a patent attorney at that stage. Before you do that, go do a search yourself on the internet. It's for free. The patent attorney is going to use the exact same database that you can use, and it's for free. We've got a lot of things on our website that says this is how you do a search. Definitely do a search. I mean, most inventions we knock out within about 30, 40 minutes of searching. So you'll have a meeting with an inventor. You'll spend like an hour and a half, 2 hours even in a meeting, discussing all of 30 minutes later, you've knocked the thing out. But you've quoted and you've got money for research. But it's money you didn't have to pay. It's a meeting you didn't necessarily have to have. So do your own search. After you've done your search, you then have a good idea as to what feature of your invention is actually patentable. Step back and go, if that's the only thing I can patent, and people can make these alternative things that are already out there because your search found them, think, is it really worth spending this amount of money trying to protect it? Or should I just be doing a design registration, for instance? I mean, as I say, most of the people that we do a search for, 90% of them, we do not file patents. Because when we go to them, we say, yes, this is great, but as your competitor could still do this, 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 I changed that, and you'll never be able to get your patent to cover any of those. Then it becomes quite clear to actually know that little bit of protection you're getting is maybe not worth the, if you think of patenting around the world, hundreds and hundreds of thousands of rands, maybe rather make the thing look good because it's a shame, it's aesthetics, it may end up selling it, and do a design registration, but spend the money rather than on designing it properly. Not necessarily trying to protect. The design registration is cheap. In South Africa, you can protect the shape of your product for only a few thousand rand. In Europe, you can cover the whole of Europe, the whole of the EU. Try to patent that, will cost you, easily 400,000 or 500,000 rand. You'll be able to cover the whole of Europe in a design registration in about 2 months' time for about 4,000 rand. The US, trying to get a patent in the US will cost you easily 80,000, 90,000 rand and 100,000 rand by the time you're finished. Doing a design registration a few months' time in the US will really only cost you about 3,000 rand. So designs are really, really cheap. Sure, they're not going to keep the other person out of the market. They're going to stop the other person from making a product that looks substantially similar to yours. But the chance are your patent wouldn't have kept him out the market anyway. So always reevaluate whether to patent, whether to do other things, especially design registrations. After going to the patent attorney, now suddenly you're free. Do your market research. They don't just go straight towards a product and go get the thing designed properly. Do some testing. It's amazing when you start making a product that everyone changes. No one changes a product from provisional to complete. No one does. No, everyone does a provisional going, and yes, I'm going to do my complete patent. And when I do my complete, I am going to add in all the new features. In theory, yes, you'll do that. No one does that. The reason is, once they've done a provisional, everyone's just sitting back and just thinking they're improving, but not doing market research, not speaking to manufacturers much. By the time they do the complete, actually there's very little to do. You convert the prov to a complete. As I say, nearly everyone doesn't add anything to the patent. And however, about a year and a half, 2 years later, when they've spoken to the manufacturer, they suddenly come back and they go, oh, I need to add something to the patent. Do that earlier. Don't wait, because now your patent is being crystallized. You can't add anything to it once you've done a complete. So definitely, once you've done your provisional, you're free to talk, but talk even before then under NDA. Speak to manufacturers under NDA. And there are free NDAs out there. Use them. Once you filed your first patent, the clock starts. you're going to be spending, if you're looking international, you're going to be spending at least, say, 50,000 Rand in a year's time. In 2.5 years' time, you're going to be spending at least about 400,000 Rand. Then you're going to be spending about 150,000 Rand a year thereafter, and things are going to just add up. So before rushing off to a patent attorney, just have a look at your product. Is it the new look? In which case it's a design. You can do that yourself. You don't need a patent attorney. What we do to file designs is, I'll show you what we do. It's the same thing you could do. It's the simplest thing in the world. It costs absolutely nothing to do it yourself. If you go to a patent attorney, they're going to hit you with a lot more because, well, they're just spending a little bit of time. But the time they spend, really, to file a design takes us maybe 5 minutes to file a design. And it's a lucrative thing, but you can do it yourself as efficiently as a patent attorney can. However, if it's a new feature that you're adding, then yes, you're looking at a patent. But we're going to discuss what the new feature is. If it's a new brand, of course, that's a trademark. So don't go to a patent attorney. Patent attorneys don't know much about trademarks. Go to a trademark attorney. They'll speak more sense than we can. But after you're even thinking of patents, think of why you want protection. Lots of people, they come in and they say, I'm not too interested in protection for suing people because I'm not really ever going to sue anyone. However, I just want something to deter my competitor. So really, give me the thinnest patent possible. I'm happy. As long as I can say patented, I'm happy. If someone says that to us, we say, well, all you're looking for is a patent number to deter. You can do that far cheaper yourself by just filing a provisional patent yourself. It's a secret document. No one ever sees it. You can put a number onto your product. You can say to everyone, patent pending for 12 months. And after 12 months, add a new little thing to your products. It need not be something that changes the tool. Do another patent pending and say it's patent pending still. You get the exact same deterrence value if you do that. Now it costs you absolutely very little. There are lots of sites out there do it for $99. Eptica is one. So if all you're trying to do is say to your competitor, this thing is patent pending, and it'll last for 12 months. And at the end of 12 months, you can see what to do. There's a cheaper option than going to a patent attorney and getting it patented. Because if you do a patent pending, just a provisional patent, the person says, what did you patent? You don't have to tell them. Say it's still secret. It's patent pending still. Hasn't been published. Still keep it secret. They can't get it from the patent office. The only thing they can see is the title of your invention, the applicant's name, the inventor's name. Unless you tell them what it is or show them the documents, they can't see what it is. They can't see your document. So whether a patent attorney drafted it or you drafted it, if you're not going to show anyone who really cares, if all you want is to say it's patented. So if it's purely deterrence, consider not even seeing a patent attorney. There are lots of things you can do yourself to get deterrence. Otherwise, marketing, this is why I would patent. Let me just tell you, we've been a law firm since 2017. I used to be at Spoor & Fisher beforehand. And despite filing, by now we've filed tens and tens of thousands of patents. Not one of our clients has ever gone to court. Not one of our clients ever sued anyone on a patent. Not one of our clients ever been sued on a patent. Not one. I don't expect anyone. It's one of those things where, if anyone does anything and does potentially infringe, you have a look at it, you design around it, you sort it out patent attorney to patent attorney. It doesn't go to court. No one's, seriously, the number of our clients who threatened people on patents, I can count them on maybe one hand. The patents, everyone comes in and goes, I need it for protection. Maybe 5 clients out of tens of thousands of clients need it for protection. Most of them actually use the patent for deterrence, for marketing. And if you're using it for that, again, there are cheaper ways to do that. than to necessarily spend all your money on patents. So be clear as to why you're actually patenting. Sure, if you're thinking of licensing a product, yeah, then you'll need to patent, because I, as a licensee, I'm not going to pay you a royalty unless you give me some kind of protection. But if you're thinking of making it yourself and selling it into the market, maybe your primary motivation here is actually marketing and deterrence, in which case you can do it for a lot cheaper. Just make your patent spend fit what you're going to use it for. So for instance, a design, I mean, you can easily do a design for 5,000 Rand. You can easily do patents for marketing for 1,500 Rand, patent pending number. Whether a patent attorney draft or you did, it's still the same number at the end of the day the person sees. Patent for protection, you're going to be spending at least, say, 60,000 Rand there, and then about 45,000 Rand per country. And I think you're going to be lucky if you get away with that. Trademarks, about 3,000 Rand. But there's a lot you can do yourself. Do as much as you can, especially the search. I mean, why on earth you're paying a patent attorney, say, for whatever 1,000 Rand an hour to do a search? And all they're doing is going through the databases, clicking on things like you can, where you can do it yourself. I really don't know. As I say, there are lots of tools that tell you how to do a proper search. It's easy to do. Spend some time doing it. You'll save a lot of money. Not the search, you'll save a lot of this patenting money also, potentially.
Hey, Anthony, may I interrupt a moment? We have a comment here in chat. Have you heard of the PQAI, the PQI, a state-of-the-art price search platform? It was developed by Sam Zellner and AT&T.
Right.
It's supposed to be apparently a very helpful platform with prior art search.
But there's so many, I mean, really, the best way to do a search, the easiest thing, go to the WIPO website, put in some keywords, see all the images, because all you're trying to do is find some seed patents. You never find your patent with a keyword search. You never do. You look for something that looks something similar, just from the images that come on the WIPO website, because you can see all the images really easily. You print that out, and that patent will then link. If that's relevant, that patent will link to the closest patents around it. And then you follow the links. The links that link where it's linking forward and where it's linking backwards. Just follow the links. That is all a patent attorney is going to do. So yes, any kind of your initial search with keywords now is your first 5 minutes of searching. It's your first 5 minutes. Once you found that first patent, you are just following links. And to follow links, just use eSpaceNet. It's the easiest website to follow links. So it's got all of those linked documents, and it's got all the links. And just follow links and links backwards and forwards of all the documents that seem relevant until you've seen all the documents again. Then you know you've finished your search. So it could take a while, but as I say, typically within about half an hour of someone's invention, you found the document that knocks his idea out. What you then do is you spend maybe a couple of hours saturating that area to find all the related documents, so that if the person goes, oh, but if I change this, but oh yeah, but this document describes that. And so, but it really is quick to knock out the invention. The core invention generally. You're just buffering just puffing up that search a bit just to see what potentially could alternatively be patented. But I mean, it may be. I mean, I wouldn't spend any money on a search thing, because really the WIPO thing is free, Space and is free, fantastic. That's all patent attorneys use. You don't need anything else. You don't have to overcomplicate searching. Let me just give you just the lifesaver story. I mean, and this is where this is really what's closest to my heart. Patents for, how people actually did use patents. Everyone thinks, people would have, the lifesaver inventor would have come up with this great idea, patented the hole in the center. Now, everyone assumes it's a hole in the center. He did not patent the hole in the center. for the same reason that a big pen lid has got a hole in it. So that if a kid were to breathe it in and it gets lodged and he's suffocating, the big pen lid, the hole, will at least allow some air through, very little, but enough for a kid. If the lifesaver suite, it's called lifesaver because that hole said if you do breathe it in, you can breathe still through the hole. They didn't patent the hole in the middle, but for years, no one made a suite that had a hole in the middle. And they called it lifesaver. And they filed a patent. And when they first came out, they said it's patented. They put a whole lot of numbers on the thing. So first of all, everyone looked at this new suite and went, wow, look at this. It's got numbers all over it, being protected all over. Yeah, it got a patent, but it got a patent for that little tear strip. The tear strip you see in that little picture, the little red thing at the end of the, now they just put that little red thing. That's a pretend tear strip. It used to be a tear strip. They never needed it in the first place. That's the only thing they could patent. So they put a tear strip on it. They patented that. And they said, our lifesavers suites are patented. Well, it was done purely for marketing. No one cared that they weren't doing that for protection. They were doing that for marketing. They were doing that for deterrence. So people went, oh, it's patented. I presume it's a hole in the middle. They actually filed a design for the hole in the middle. And that's what you should have filed a design for. Then, of course, they filed a trademark for lifesavers. And because everything pointed to the same thing, it reinforced the thoughts in everyone's mind that what they actually patented was a hole in the middle. So it took ages for Polo to come out of the suite that had a hole in the middle. But, I mean, really, really effective use of patents. But don't spend too much on it. You're using it only for marketing. So spend very little, go in a few countries, rely on your designs, which are exceptionally cheap. So, I mean, basically, if your product looks different, it doesn't matter if it's only slightly different. As long as you put two products next to each other and people can spot the difference and actually spot a difference, your new product can be design registered. You don't need to have a whole new product. As I say, if I take this big pen and I decide I'm going to make this little push thing at the top, if I made if I made that suddenly 3 times longer with a little ball at the end and wavy, well, I can design register my version of the big pen. It won't stop someone from making the original big pen, no. But I'll be able to design register my big pen that just has a small difference here or a small difference on the clip, which would prevent others from making a big pen that includes my small difference. So the fact that it's small doesn't really make a difference for design. If I made only a small change to an existing product, all it means that my design registration would require my competitor to make an equally small change to my product. So if I decide I'm going to make a tiny change to this clip over here, my competitor needs to make an equally tiny change to the clip to get around my design registration. If I make a larger change to the clip, he has to make an equally large change. So that's how designs work. You don't have to, so basically anything that you make, you can do a design. And when you do a design application, you straight away can put the number on your product. And your number there looks just like a patent number. It's just got an A at the front of it, or it's got an F at the front of it. Most people in the market, when they see a number on a patent, on a product, they assume it's a patent number. A design has got great deterrence. Sure, it stops them from making a copy, but anyone who picks up your product is going to see this number on it, and sure, it's going to start with an A and F. You think they're going to go and check if it's a design or a patent. They're not. That's going to go, and you can put in reg number and put the number. And if people see reg number and a number behind, they're going to assume it's a patent. They're going to say, oh, I better not touch this thing, just like they did with lifesavers. So do a design, do it yourself. Use photographs. You can use drawings, but use photographs. Any photograph of this against a white background, and you can take a photograph, front view, back view, bottom view, top view, nice perspective view. That's all you need. Upload those photographs, put in your name of the applicant, choose which class it is, and that's easy enough. And you filed your design. There are websites that allow you to do it. and it will cost you absolutely nothing. It'll take you 5 minutes. You can do it on your cell phone. You don't even need a computer to file a design. I mean, just a few ideas here. And even if you've brought this out into the market, you can still file design within the next 6 months in South Africa. You can still file design in Europe and the US within the next 12 months. So you've got a lot of time to file designs. You don't need to do a search on like a patent, because you know that, even though something similar could exist, nothing identical is going to exist. And it's going to be so cheap. I mean, look at these examples. This person had a great hat, which frankly, I think looks like any other hat out there. He may have just had a new hue of blue. I don't know what he had, but the design can also be a color. So the fact that he may have had his own hue of blue on an existing hat, he can get a design registration, put a number on it. The one person had a very unique way of making a sling. Not quite sure what's new about that, but that's design registered, and she can now sell this thing with a design number as if it's that little swatch of material. That's a clear offcut. Oh, just took a photo, filed that, and got a design registration. The photos don't need to be great. They just should be against a white background. But the lady in the sling didn't think it was necessary. So, and all those designs were registered, by the way, by the South African Designs Office. So they never didn't decline a design registration. All you need to file a design is the name of the article, lip ice, or Vaseline, or lip protect. Call it whatever you want. Doesn't matter what you call it. It's not affecting your design registration. Whether it's an aesthetic or a functional design, a class, and that's, that's easy to find once you're on a platform that allows you to do it. The applicant's name, who the owner is, his address, and photos of the product. That's the only thing you need. It'll take you a few minutes. I wouldn't, if I was an inventor, I wouldn't go to a patent attorney to file a design. I love filing designs. It's the easiest income we can make. I mean, these are all.
Can I interrupt you again, please?
Yeah.
We have a question here from Ben. What is the difference between a copyright drawing and a registered design?
Well, the copyright drawing doesn't. So all the copyright drawing prevents someone from doing is making a copy of that drawing or making a reproduction of the of that copyrighted work. But if the thing is supposed to be manufactured, then copyright doesn't cover it. So you may have engineering drawings of this with nice views and dimensions and everything else. Sure, that copyright prevents anyone from stealing my drawing pack and making copies of it. But frankly, that protection does not extend to making this lip ice and selling it. It doesn't. So copyright, frankly, unless you're singing a song, unless you are, writing a book, unless you are painting a painting, taking a photograph is not relevant. It's not relevant to products. So if someone puts a copyright symbol on this, you ignore it. The only thing that may be copyrighted is the lip ice. So the lip ice, sure, it's a trademark, but there may be, the kind of artistic input that's been put into that, yes, that may also be subject to copyright. But the trademarks what the person would be relying on. So copyright is not relevant. Ignore, and you don't have to register copyright. It's for free. As soon as you make a drawing, take a photograph, it's there. You don't have to spend any money, do anything. It's automatically copyrighted. So, but equally, it's cheap, but it's equally as useful. It's got very little use to products. So these are all just registered designs in South Africa that have all used photographs. So don't be scared to use, don't go, oh, lots of people, they seem to use drawings. No, everyone uses photographs these days. It's much better. And I mean, there's a lot of things. I mean, even if you bring out a new burger and you think your burger looks great, take a photo of it, do a design registration, and then use it in a bit of marketing. IP does not have to be for boring protection. It is for marketing. Audi brings out a new car, and the A6, and it says the A6 got more patents in it than the space shuttle. And everyone went, whoa, got to get an A6. Frankly, every car had more patents in it than the space shuttle, because every car's got a shock absorber made by Bosch. If you ask Bosch how many patents are in that shock absorber, there are many it can refer to. The headlight will be made up, be 3M, it'll be the plastic. They'll have a patent on it. If you add up everyone's patents, every car's got thousands of patents on it. Wasn't necessarily, you know, I mean, and the 9,600 patents, it would have been like South Africa, and then I'm going to file in Timbuktu, and I'm going to file in Madagascar. I'm going to extend this thing a few times. And it meant nothing, the fact that they had 9,600 patents, but it made people go, wow, from a marketing perspective. It was great for marketing. When you had Zuckerberg trying to list Facebook, Zuckerberg was going on this whole roadshow and saying to everyone, oh, you've got to invest in Facebook. And every time someone would put up their hand and go, that's great, but you're forecasting in your valuation your earnings for, you know, a good 15 years. How do I know that tomorrow, just like you came up with Facebook, how do I know tomorrow you're not going to have, you know, another thing, Face movie coming out, that's going to be your market? How do I know that? Zuckerberg kept on having to answer that question. He got sick and tired of answering it, and everyone was discounting his valuation because the discount rates went up. So what he did, instead of trying to answer it, he went out there and got a patent that in the title had anything to do with social media, anything to do with networking with people, anything like that. He went to Australia, he went to every country in the world, and any patent that had anything in the title, it could have been the most useless patent. But as long as the title looked good, he bought it. And he didn't buy it for much, because most of the people who had these patents weren't using them. So frankly, if they got 50,000 Rand for it, well, that's great. So it would sell for 50,000 Rand per patent. And he ended up collecting over, it was thousands and thousands of patents. And then when he went and he spoke in front of the potential investors, they go, what, sorry, Mark, what would stop your competitor, Joe, down the road from you, starting up a similar thing and competing with you? He'll stand back and go, have you seen my bag of, 6,000 patents? And I go, oh, okay, that was a stupid question. Not going to ask that again. It was used for, to deal with all those questions, again, for marketing, for reducing the discount rate, for satisfying people's questions. The same way that Audi said about the space shuttle. And well, it's really useful. It's not just for boring protection. As I say, I think less than 10% of inventions would, the person's actually going to use it for protection. For trademarks. So trademarks is the thing, the brand you're going to give it. I'm just touching on this because most people, they call up and they say, I need to patent my brand. It's, of course, any name. And there's lots of the Eptica site. You can put in the name, you can put in the class that you're interested in. And it can then tell you if the mark exists, has been registered or not. If it hasn't been registered, play around with similar things. And if it hasn't, you can do the registration yourself. Trademarks is simple. You basically just put the name, Lipas, the applicant's name, Anthony van Zantwijk, and the class. In this case, for clothing, class 25, not for Lipas, but in this example, for the search, class 25. That's the only input you need to file a trademark application. You can do trademarks yourself. It's the easiest thing in the world. And again, there's systems available that assist you to do that. Let me just give you because I'm going to give you a few examples that I keep on giving you as we go. So Rolo comes out, and when they first brought out Rolo, everyone was like, wow, they made a big thing, it's patented. And so everyone was seeing this new sweet patented. Wow, that's exciting. It's a sweet. I wonder what's in it. Is it this really creamy, juicy center? Everyone was intrigued. Everyone goes and buys Rolo. Is it the way they're packing it? Is it the way it is this frusto, conical shape? No one had a clue. What they actually patented was take a stack of sweets, you wrap it in tin foil, and then you put a paper wrapper around it. That is what they paid. It had nothing to do with the sweet. It had nothing to do with the toffee center. It had nothing to do with how creamy it was. It had nothing to do with that. I mean, popping candy was patented, but that at least had something. It was compressed gas in sugar. So you melt the sugar in a pressure chamber with compressed gas. You have all this gas that goes into your sugar. And of course, when the sugar then solidifies, you take it out, you crush it, and as it's melting on your tongue, all gas bubbles are popping all over the place. It isn't a chemical reaction. It's just because the gas bubbles are under pressure because that sugar was solidified in a pressure chamber. That's all it was.
Anthony, may I interrupt again? When you trademark, are you protecting just the name, or do you also protect the logo along with the name?
Well, like I say, take here, Rolo. Rolo, you've got your logo, Rolo, but as soon as they use the logo, they're saying Rolo. So, I mean, if someone came to me and said, I'm going to do a word mark for Rolo, so just the name R-O-L-O spelled out in capital letters, that you must do. But then I'm also going to, because I really like the way I've written it here, I'm also going to protect this as a logo. And I would tell them you're wasting your money. Of course you're wasting your money, because as soon as you write it like this, you're still writing Rolo. So the person is still going to infringe your word mark. I mean, you can always overlap it, but if you're trying to save some money, don't do it. And you can always do it later. So like KPMG, when they have their nice logo and they have all these blocks, but it still says KPMG. I don't know why anyone's spending money trying to protect that, because it still says KPMG. The word mark covers it. But Lacoste, for instance, where you put the crocodile on and you're not saying Lacoste, then yes, there you need to do the logo. But only do the logo if your logo does not include your word mark. Why on earth anyone files a logo where the logo includes the word that they're protecting as a word mark? I don't know. Doesn't make sense.
So, Anthony, are we just trademarking a name then?
Unless it's Lacoste's crocodile, because Lacoste crocodile, some shirts, they don't say Lacoste on it. So because you're not saying Lacoste on the logo, then yes, the logo makes sense to register. But if I'm doing, say, General Electric's logo, and it's still got GE on it, just do GE as a word mark. I mean, why you then spend the same amount again protecting it as a logo, I really don't know. Because anyone who's going to copy that logo is still going to infringe your word mark, GE. It's still saying GE. So basically, if your logo includes your word mark, question why you're registering your logo. It doesn't make sense to me. Okay, so now for the patent. So now you've done your search, or you're about to do your search rather, but you need to identify what is new. So let's just take this by way of example. So let's say a feather, a quill, was known as a writing instrument. So you come up with the pencil. What is new? I mean, writing instruments existed, it was a quill. But the quill basically had fluid in it. So what's new about the pencil is that you've got a writing instrument, you've got a body being your wood, and you've got a solid writing element inside of it. Don't say it's graphite. Don't say, well, it isn't lead, but definitely don't say it's lead inside of it. It's just a solid writing element. I don't care if it's a colored wax, if it's graphite, if it's later on your patent, you can say it is graphite, because that's really what it is. But that is what, therefore, you should be searching for, is a writing instrument with a solid writing element inside of it. Let's say the pencil now has been in the market for a while. The person comes up with the big pen. What's new there? Don't tell me it's a writing element with ink inside it, because a quill had ink inside of it. So compare your big pen to the quill. What is new is the fact that you've got your reservoir inside your body, which the quill had. But now what you've got is you've got a regulator, that ball on your big pen that regulates outflow of fluid from your reservoir. You didn't have the regulator in the quill pen. In that drawing, yes, because that one's got a little pen on it, but let's assume that was just a feather. So if you came up with a big pen, don't go looking for pens with ink. That already existed. You're looking for pens with ink with that regulator that regulates outflow of fluid from the reservoir. And any regulator, you can have a board, but any regulator, because then you need to know how narrow you need to claim it. So let's say the next person comes up with this pen that clicks, like this one. What is new there? Clearly not the writing, clearly not the body, clearly not the ink, clearly not the regulator. That's all it has existed. So what is new now is that you've got an actuator for moving the regulator from within the body to outside of the body. And the actuator here is whether it's this clicking mechanism or that thing on that slide, doesn't make a difference. Your subsequent claims, you can be more specific. But your claim one, you're looking for an actuator that moves your regulator from within, between, inside and outside of the body. And that's what your search needs to focus on. If you find something that has those features, it exists. Yeah, it isn't new, you can't patent it. And so you're always trying to find that in light of what's come before, what is the feature that is new? If you go speak to your patent attorney all about the fact that you've got this ink, and it could be blue ink, it could be red ink, no one cares, it's not relevant. The fact that it could be a nice ball, what is new here is your actuator. That is what is new. So once you've identified that feature, of course, do your search. It's free. There are lots of websites to do it on. Now, it doesn't have to be the greatest thing in the world. Eskimo pie, they came out. They were the first people they got a patent on it. And I mean, everyone loves Eskimo pie. I mean, Eskimo pie first came out, absolutely no one copied them. But all they did is they basically patented ice cream covered with another material, edible material, that has got a higher melting point than the ice cream. It happened to be chocolate, but it could have been anything else. And they got a patent for it. At that time, I don't know really how new it was. Remember, this was a long time ago. And so maybe the examiner hadn't really seen a lot of ice cream before. But basically at that time, chocolate coated ice cream was absolutely patentable. And so it need not be anything completely, amazing. Anything that is new, you can pay. But here again, what Eskimo pie ended up doing, they ended up trying to enforce this patent all over the world. They ended up going bankrupt, the original guys, because they had a patent that was extremely thin. And they were suing people all over the place, trying to maintain their monopoly. They spent all their money trying to enforce their patent. They went completely bankrupt, and the courts basically weren't that interested in enforcing because they thought, the judge always thought, well, that's just a chocolate-coated ice cream, which is all it was. And whereas what they should have really done, in my view, is use it as a marketing thing, use it as a deterrence. Don't spend too much money trying to enforce it. You're not going to enforce it, but use it for marketing, use it for deterrence. Get whatever you can out of it and then walk away. So now the feature that is new has got to be something you can point to. So don't go to a patent attorney and say, I'm going to put oil into a Coke bottle. No one's ever put oil into a Coke bottle before. I'm going to use my Coke bottle for a new purpose. A new purpose for an existing thing is not patentable. You've got to be able to point to something that is new on the thing. So here, if someone came and said, I'm going to put oil into my Coke bottle, I'm going to say, oh, great. Is that because the normal seal on a Coke bottle lid, does it react with oil? And therefore, have you put a new coating on it that doesn't react with oil? In this case, maybe. But if he says, no, it's the same Coke bottle, see, I'll go, oh, there's nothing patentable. you know, say, give it a good name, do a trademark, get it out there, but don't waste your money patenting it, at least not through us. Don't patent a novel combination of things. Another thing that everyone seems to want to patent. I'm going to add this to that. And then no one's ever added this to, like a Swiss Army knife that has, you've got an 8-piece Swiss Army knife, and you've got a whole lot of combos. You've got a 32 whatever piece Swiss Army knife. And then someone goes, oh, but no one's ever put this other tool on a Swiss Army knife. Who cares? You're just combining something else with something else. So a 3-in-1 printer. If someone says, I'm going to add a fax machine with a photocopier and a scanner all together, no one's done that before. I'll say, yeah, but if you take a box and you throw a photocopying machine in the box, and you throw a scanner in the box, and you put a fax machine in the box, you've now got a box with all three in them. Now, whether you make the box pretty and you house it nicely, it's still the same thing. You put all three into a nice box, like this 3-in-1 scanner, photocopying, and fax machine. There is nothing patentable about combining things together, unless there's an unexpected result. So if you were to say to me, yeah, no, it may not look, but for instance, the photocopying machine gets used all the time, and you've got this heating element there. And the heating element, if you put it, let's say, between, you know, where the fax machine is, that it gets used far less frequently, then that same heating element heats up the fax side and the photocopying side all the time, therefore increasing. And it'll be thin as anything, but at least you've got an unexpected benefit. So don't come say to me, okay, you're going to share a heating element. We need to have a reason why it's an unexpected benefit. Photocopying machine is more frequent. So while it's always running, it will keep the fax thing always warm. And we will therefore put the heater on the photocopier right next to where the fax heater needs to be, and we'll save. So fax can run much quicker then. Doesn't need to heat up.
Anthony, if I can interrupt you, yeah. Elton has his hands up.
Yes.
Elton, please go ahead.
Sure. Anthony, very, very informative. I'm enjoying everything. The whole presentation is really outstanding, and I'm learning a lot as we're going away. My question is back on the quill slide with the pens and the quill comparison there. If let's say, for example, I'm still on the quill, and I'm the quill, so I'm the one that's manufacturing the quill. That's my innovation. But I'm aware of all the innovations that may occur. Is it possible to then protect that so that the pencil and big pen and the smart pen don't get created by my competitor? So I think it's similar to the Mark Zuckerberg example, but like I'm just ensuring and protecting my asset, despite the fact that I'm aware that there might be much better innovation later.
Absolutely.
That's my question.
Yeah, absolutely. You don't commercialize your patent generally. There are countries where you do, India, for instance, but everyone then just pretends they don't. But you know, so there are a few countries where they say you've got to commercialize in so many years of registration, but most countries in the world, no, you don't have to. So yes, you can just foresee, file patents for it. Now remember, like most countries, they've got unity of invention. So your patent for the quill pen will not, that same patent will likely be able to cover the big pen, because you'll be able to do your claim on being a body, reservoir, writing liquid within the reservoir. That covers your quill, but the thing is that likely would have existed because any feather that came off a bird where it was in the ground and someone stood on it and got a bit of mud into it, well, there you've got writing fluid within the reservoir of the. So it'll likely be a bit thin. Right. But claim 2, you can add your regulator. Claim 3, you can add the actuator for moving the regulator. So in the same patent, you'll be able to cover the 1, 3, and 4. And you can't, because in claim 1, you talked about liquid writing fluid. You would have to do a separate patent for the pencil, because that'll be a solid writing element.
Perfect.
So
It's just
patents.
Right. The process itself, would that also be possible to patent it? Let's say, for example, quill, pencil, pen all have the same apparatus, obviously, to write notes and everything. I want to protect that. So if I could just give an example, everybody's running to space right now. Elon Musk, Jeff Bezos. If NASA had come out and said, you know what, the commercialization of space, that's a no-go zone. Would that also be something that they could actually stop in terms of the service and not necessarily the product of?
No, that's a business method. So you can't patent business methods, no. So business methods, no. So services generally, no. So you need a method step. If you have a new method, like the method in which Uber calls a cab, most of Uber's patents, most software patents are method steps. You would have to have a new and inventive step in your method, which in Uber's case was very, very difficult to find, actually. But so no, generally, and for instance, let's just go with your writing element example. If you thought that you would be able to do a patent whereby, say, a user making use of a writing element and then passing it over a piece of paper to leave some kind of writing fluid or some markings on the paper, that would be a method. But then there will be someone taking a rock and just rubbing a rock against another rock. He's also making a marking. But basically, you never really want a patent that covers a method. The reason is you want to sue the manufacturer. You want to sue the importer. You want to sue the retailer. That's where, because if you sue the importer, you cut off at the knees. If you sue the retailer, you stop it right there. If you have a method patent, you can't sue any of those. You have to go follow some poor person who's going to buy the thing at the retailer, take it home, use it, and then sue him and sue every user. I mean, you're not going to stop it. So method patents are pretty useless. Go for an apparatus patent if you can.
Perfect.
Okay, one more interruption, please. Sorry, Ben. Sorry, Elton. A question from another person. Can a registered design be applied to an original patent? For example, a redesigned product so that no form tooling for bending is required.
Oh, the design just protects the shape of something. So design doesn't say, so no form, no tooling is required. It's just after you've made the product, you take photos and you protect the shape of it. So as long as you've got a new shape, this product may have been patented, but even though it's patented by someone else, if I make it look better, I can still design register it. Sure, I may not be able to make it because of the patent on the product, but my competitor, the other person who's got the patent, will not be able to use my design. If he wants to use my design, he has to pay me for it. And that's where the value may come in the design. But
if the shape changes?
Sorry?
If the shape changes?
As I say, if you've made only a small change to what already existed, your competitor have to make an equally small change to your product. So if, let's say, this has only come out in a nice right circular cylindrical tube, like Lepi's first used to come up, and the first one, Brian Steinhobe already did this with a nice oval cross section, then yes, your design would have, it wouldn't then stop someone from making it square, because a square from circle is about the same distance as making circle to oval. But if the person starts making it oval, still making it oval, the chances are he'll still be infringing my design, because he needs to take a step away from mine that is equally as large as a step in shape I took away from the closest pre-existing thing. Okay, so thank you. I make a small change, he needs to make a small change. I make a big change, he needs to make a big change.
Okay, thank you.
Right, so and let's just say you've got a range. So let's just say I'm making bread, and I've got this. If I keep my oven between 181 and 183, best bread in the world, and no one's done that before. and I'm patenting my range, you have to be able to prove something special happens at those points. So if the examiner goes, okay, what happens if it was 180? You go, no, it will still be the same. I just don't think it is as nice. You won't get a patent. Something special needs to happen at the ranges. So you can't say, I'm going to have a patent over me making a cake, only because I'm going to put very specific kind of, percentages in. It is exactly 20% cocoa. It's exactly 21% sugar. And you have to show that something special happens at that. Of course, you can get a patent pending number for that, but to get a proper patent in an examining office, you're going to have to show that something special happened at 21% sugar. If it was 20% sugar, it wouldn't have activated that enzyme. If it was 22% sugar, it wouldn't have activated that enzyme. But at 21% sugar, you add in the lemon and this activation happens. It's great at 21. Then you'll get a patent, but very few things are going to happen that way. So when people say, I've got this new skin lotion, lovely new skin lotion, I'm going to put cocoa butter in, I'm going to put, all he's doing is playing around percentages. There's nothing patentable there. Do your formula, get a patent pending number. It's great for marketing. It's great for deterrence. Wonderful for marketing. But don't waste money with a patent attorney, because you're going to get a piece of rubbish on a piece of paper. It's not going to be enforceable. Okay, method, as I said, software is generally a method. It's always a method claim, but we're not going to go into software now. But if you can't patent, as I say, before running off to the patent or even filing your provisional patent, do as much as you can under NDA. You get lots of free NDAs. There's one that you can create by just ticking boxes. You say who you are, you put in, and then you just download your PDF document. And it's a pre-populated NDA. It's a very good one. It's one that we did for Anglo American and De Beers. They rolled it out throughout their group. It was good enough for them. It's good enough for you, likely. Jelly bean. Guess what jelly bean? Because when jelly bean first came out, they patented it. And what they patented was sugar-coated marshmallow. Full stop. Marshmallow with a sugar coating. And at the time, it was new. How exactly inventive it is, I'm not too sure. The chances are they said it was invented because maybe the sugar coating stopped the oxidization of the marshmallow, or the little volatiles in the marshmallow, or the fluids there escaping. Likely that's what they said. They made up some story and they patented. But there again, do not try to enforce this thing. You're not doing this for protection. You're going to do this for marketing, because when you come out of jelly beans and you go patented, guess how many people, if there was a jelly bean that was patented, I would buy it. Just to go, because I'm expecting something extravagant here. I'm expecting something more than just a jelly bean if it's a patent. Imagine you go to a shop, you see jelly beans, and the one thing says patent pending on it. What do you think you're going to buy? You're going to be expecting that kind of space candy popping excitement from your jelly bean. You'll likely be disappointed, but you still have bought the product. Very useful for marketing. And to patent something like this, all this person would need to do is say, it's a confectionery, or it's a foodstuff that includes a marshmallow made of, and it says cornstarch and sugar, and with a sugar coating over it. And just give an example, how to put it, whether you dip it in it, then it'll dry, I don't know. Put a sugar, and then in your claim, you just say sugar coated marshmallow. That's all you need to say. And it'll be a little paragraph, it'll be one claim, be half a page long. It'll take you, a couple of minutes to write. You go to one of these websites, you put in the applicant's name, you upload that document, you put in the inventor's name, it's you. You download the assignments and the P forms, you sign it, you upload it, you pay, in this case, $99. The very next day, you straight away file it. The very next day, you'll get a number, and all around the world, you're able to say patent pending, so on your product. So, and if anyone, and put the number, South African number on it. you have to put ZA, you put just Pat penned, put the 2022 / whatever number. And everyone's going to look at it and go, wow, okay, it's patent pending. Whether you've got a great patent or not, no one's going to know. It's very, very useful. This is the kind of thing that you need to say. You just need to put in the title, applicant's name, applicant's address, inventor's name, inventor's address, download the forms, upload them over here, or you can sign electronically, tick the box, done, pay by credit card. 1 minute, you filed your patent pending number. Next day, you've got a number, you're using it wonderfully for marketing and deterrence. Levi's came out with their jeans, biggest jean company in the world today. Guess what they paid? When they first came out, they told everyone, patented. They made a huge thing about the patent. The only thing that was patented about the Levi jeans was a little rivet on it. Now, if you said to most people who were making pants at the time that, well, you know what, jeans, I mean, you're expecting to protect the denim. You're expecting to protect a whole lot of things. And imagine if you came up with jeans and I, as a patent attorney, said, yeah, that's great, but the only thing you can protect are these little rivets in the pockets. And you may say to me, but Anthony, I don't really care about the rivets. I mean, they're nice, but you can equally not put the rivets on. I mean, 99.9% of pants don't have rivets, and no one cares about that. So is it really worth patenting my jean pant with a rivet on the corners of these pockets? The answer is absolutely yes, if it is for marketing. Because now you can sell your jean pant as being patented jean pant. But people going, wow, there's got to be something new. It's not just your average pant. There are many pants out there. So as I say, before thinking what you're going to, just why are you doing the patent? And if you're going to do it, and it's going to give you very little protection, I mean, that patent, seriously, if you're just doing your own provisional patent, all you're going to say is a pair of pants with pockets, where at the ends of the pocket openings, corners of the pockets, there's a rivet. Full stop. Claim one. Pair of pants with pockets, where at the extremity of the pocket openings, you've got rivets. That's all you have to do. And you've got a patent. It'll take you a few minutes to draft the thing, upload it, costs you nothing. And now you can say patented or patent pending pants. Of course, if you're going for a proper patent, the patent attorney will have to draft it, but that's a really easy patent. Let's take it to the extreme. Pantene, the greatest. This is a greatest patent story ever. Here we had a shampoo company, thousands of shampoos out there. And there's nothing new in the world of shampoo, really. There's absolutely nothing new. Pantene wants to become number one. They have no idea how they're going to do it, but they've got this great marketing strategy. They analyze all the shampoos, and they realize that you've got these lovely panthenol ethyl, whatever, ester, and panthenol, whatever. These two chemicals with P's, if you put them together, they're great for your split ends. One problem. So many shampoos beforehand had the same chemicals in them. So it wasn't new. Okay. So what they did is they analyzed every single previous shampoo that had this chemicals in it, and they looked for the ratio of these two chemicals in the shampoo. And they plotted those ratios on the graph. And they realized that for some reason, not a good reason, but it was a technical reason, absolutely no shampoo manufacturer had ever put these two chemicals in this one specific ratio. Nothing really new about it, nothing exceptional, no, not necessarily any unexpected benefit, but there was a gap there. So there was this one ratio that when they analyzed all the shampoos, no one had done before. So what they did is they filed a patent. Shampoo with these two chemicals in this specific ratio. What they then did is they got a whole lot of scientists to go how at this ratio, there's something special that happens. And they bamboozled the examiner, and the examiner went, I don't even understand this because this is chemistry, and no one really, I mean, I don't understand chemistry. So he kind of went, okay, I'm seeing all these graphs, all these things from all these tests. And, okay, And I can accept it's new. You've given me all the evidence and no one's done this ratio before. Okay, so he patented it. Now, Pantene wasn't dumb enough to go in the ingredients, it's got these two chemicals, because every other shampoo said it had these two chemicals, because you've got to say what your shampoo has. And so what they did is they coined a name, Pro-V. And they said these two chemicals together, I'm going to call it Pro-V. Now, I don't know, does anyone know what Pro-V stands for? Protein, vitamin? Maybe. I mean, proteins are good for you. Vitamins are good for you. So Pro-V, maybe. Or it's like pro is in really, I don't know what pro. They just coined it because it sounded protein, vitamin-y, pro is in good. Anyway, they registered the trademark. And these two chemicals in this exact ratio is Pro-V. So now they don't say on their shampoo bottle, I've got these two chemicals in this ratio, because everyone else, if the buyer looks at everyone else, they go, oh, so it has that, and everyone else has got it. But now that they say Pantene with Pro-V, everyone goes to all the other guys and go, oh, it's got Panthenol, but it doesn't have Pro-V. And that one doesn't have Pro-V. Of course they don't have Pro-V. They're not allowed to say Pro-V. It's trademark registered. So only Pantene is allowed to use the word Pro-V. So come up with a combination of chemicals that maybe, but yeah, and find a little ratio that may be new. At least it's new. It may not be that inventive. Do a patent pending. Call that combination something. Trademark register, and then market the hell out of the something. Market shampoo with Pro-V, then on your marketing stamp, patent pending. Everyone goes, oh, gee, this is shampoo's got Pro-V. I've never heard of Pro-V before. It must be great. And it's patent pending, so clearly it is new. And clearly it's got a technical advantage, because otherwise it wouldn't be patent pending, surely. So it must do something. So everyone now wants to try the shampoo Pro-V. Pantene brought out this shampoo. Within a year, they were the largest selling shampoo manufacturer in the world. No one was able to do that. And it was all by just finding two little chemicals that frankly were not new, plotting the ratios, finding a unique ratio that frankly had no benefits, filing a patent only to when you say, because if you say, I've got new Pro-V, you're going to go, yeah, it's new. But if you say, it's new Pro-V, patent pending, everyone then believes it's new. Or even better, patented. Everyone then believes it's new. And then you market that yours has got Pro-V and it's great stuff. And because no one else allowed to say Pro-V, and you say to in your marketing, all the customers need to be looking for Pro-V everywhere, they're going to look everywhere and they won't find it anywhere else ever. Your patent would have only lasted for 20 years, but customers who want Pro-V are going to be buying your shampoo forever, because never is anyone else allowed to say Pro-V on their shampoo. Greatest marketing story. But it was pretty useless from a patent perspective, because you could not keep the other guys from also putting the same, but they weren't marketing the Panthenol and Panthenol ether. They weren't marketing it.
Anthony, we've gone quite a lot over time.
No, and
it's been absolutely fascinating. So thank you very much. I'd like to just ask one question, if I may. When is the right time to do a patent pending application? When you consider you've only got 12 months.
Well, it depends what you're doing it for.
You come up with your idea. Do you go and do your search and do the patent pending then? Or do you do a lot more work first, then do your patent pending before you start marketing?
So if you're doing it for protection, if you actually want to sue people and you're doing your patent for protection, you just file your provisional just before you need to make your first public disclosure. I would do as much as I can. Go to the designer, go to the potential manufacturer under an NDA and do that, because it's going to take you a very, very, very long time. And just before you need to make your first public disclosure, or you're starting to feel uncomfortable about all these NDAs, then do a provisional. But don't rush and do a provisional. If you're doing it for marketing and deterrence, I'll do everything under an NDA, because all you need to do is just keep it that the thing is new still, whatever, how thin it may be. And then when it gets to just before you have to publish, which would be just before really launching the product, because you want to use it for your marketing, do your patent pending, and then launch it, because then you've got a whole year of patent pending. You know,
okay, then, and just to clear a point, a person themselves, an inventor, somebody, they can do a patent pending application, a PPA, themselves. But to do a utility patent or a full patent, you've got to go through a patent attorney.
Correct. Correct.
Okay.
Correct.
Okay.
And when it comes to, say, using it for marketing, I mean, there's, if you look at Eptica, there are so many examples. There are so many products, software, Uber, Waze, all of that. Everyone uses patent pending for protect. The intention was not to sue people. That's why you've got so many other products that lift. Everyone's doing the exact same thing. There's no patent infringement. I mean, for instance, the Uber patent. You know what the original Uber patent actually covered in the end? The fact that, I mean, I could have copied Uber system exactly, basically. But as long as when I confirmed my ride, the map wasn't still on the screen, I would not have infringed the Uber patent. So in other words, I could have copied the system, but before confirming my ride, are you ready to confirm? Yes. Remove the map. Big confirm button, confirm ride. Map comes back. That would have been the only change I'd have needed to make. Now I'd have got around the original Uber patent. No, so, but it wasn't there. That original Uber patent was there for marketing, but for the investors. So what happens is Uber would do this massive document describing everything about the system, everything else. And the investors would be looking at this huge document. It took 9 and something years to be granted. It took very long for it ultimately to be forced into a valid state and be granted by the patent office. But for 9 and a bit years, all the inventors were going through this massive document going, oh, this thing covers everything. And the investors were then happy to keep on investing money into it. And it did its job. You know, it was pretty useless for protection. It was great for the investors to be comfortable to keeping on putting money into it. You know, so everyone's got this focus on protection. As I say, you know, if 5 people have ever, you know, been threatened with court action, it's a lot. Out of tens of thousands. It is, in reality, it's no, lots of big players, they use patents for a lot more kind of imaginative reasons, imaginative ways, the whole Pantene thing, than what most South African inventors do.
Actually, my last and closing comment is that if you, I mean, you've had extensive experience for obvious reasons in patenting and in the PPA. Now, as an individual person, is there any area that, or book or source of material that would help the individual learn faster about PPA than by doing the job only? Is there a book that you know about?
We've got a lot of material on the IdeaNav website, especially on how to do it yourself. So everything that we have on the IdeaNav website, whether it's from searching, whether it's design registrations or provisional patents, it's even got templates. So you don't need a template for provisional patents. There's no format dictated, but if you want a template to help you, it's got them there. It's useful, but yeah, there's a lot on there. You see, what we try to do is, now, as our focus is incoming patents from around the world. But insofar as we also can help inventors to do as much as they can themselves, great. That's our focus.
Okay. Does anybody have any questions? Last call. Gavin, please go ahead.
Okay, thanks, Anthony.
fantastic presentation. Just two quick questions. So the first one is around people doing their own search. So I completely get it that you must do your own search first, because your time is a lot cheaper than a patent attorney's time. My concern, though, having dealt with lots of inventors, is that they're not completely objective when they do their own search. So, for example, if they do a search and it comes across something that invalidates the last 6 months of work that they've been doing, and as you say, knocks it out in 30 minutes or even within 3 or 4 minutes, like that's just too much to handle. You know, the cognitive dissonance in that is just like, you know, they have to find a way to justify it. So they'll end up looking at that patent and they'll go, oh, it's not the same as mine, because mine does X, Y, and Z, and this does this, and therefore mine is completely different. But in reality, as an objective patent attorney, you go, that's the same thing. Who are you kidding?
And the most common one is that the inventor will say, oh, but this thing still has the problem. It won't work because it still needs, and that would be, and they'll diss that patent and ignore it. So look, if the inventor is not going to be objective about it, then there's no use doing the search. But I mean, doing your own search is no downside that way. The worst thing that happens is that you throw the relevant patent away, or you don't find the relevant patent. The best, but then you haven't lost anything because you didn't know in the first place, and you're still going to go through the process. And I mean, when we used to do a lot of searching, as I say, even if the inventor had done his own search, we would still do it ourselves because we didn't want to spend time drafting a patent unless we had made sure that there was actually something novel there. But yeah, I take your point. Inventors doing their own search, there are problems. You can't force them to be objective, but there's just no downside to them trying. At least when they go to the patent attorney, they can say, this is the closest thing I found, but I don't think it's relevant. And then the patent attorney can tell them, actually, it is really relevant.
Yeah, interesting. Okay. And then just the second question is this whole thing around doing a design registration. So I completely get the marketing angles, and you've done a brilliant job tonight of picking examples to show that the value of most of the stuff is actually in the marketing, with practical products and things that we've all heard of and know of and didn't know anything about. So that was really fascinating. Well done. I mean, that was fantastic. The question I have is, I mean, is there any value from a protection point of view in a design registration? Because from what you're saying, if I'm understanding it correctly, if you're the first one to come up with a unique design, all someone needs to do is choose some small irrelevant aspect of it to incorporate, which allows them to completely use that design, even though what they added has got no relevance to the functional utility of the product. And equally, if someone else has got something and then you go, oh, I had a similar idea, but look, someone's done this. You come up with a flippant extra addition, add on something, some extra little strip somewhere, and you go, okay, this is now a new thing. Now, all of a sudden, I can use this design that I'd come up with, even though someone else has come up with it before. So if that's the case, what's the point?
So yeah, if you're looking actually for protection, as I say, I mean, it's not going to keep the person out of the market, but it's going to stop him from making it look that similar to yours. So a copycat product. So in other words, if you start marketing yours and lip ice, I mean, people are starting to get used to that it's in this oval cross-sectional shape, and then suddenly another person is selling lip ice, but it's round. People are not going to get it's really sure. They may remember lip ice and go, I want lip ice. But if they have seen a product, they're going to, the design will basically prevent the other person getting that close to it. It'll be that confusing. So in other words, I've seen it and I kind of want that product. And now they see something similar and they go, oh yeah, that's the product that I wanted, and they buy it. The design would kind of prevent the person from coming that close to cause that kind of confusion. But there again, nearly no one ends up suing on a design You know, designs, you have maybe one case that goes to court every few years in South Africa. Because why on earth would I go to court if all I need to do is, yes, make a few changes to my product, because it's not going to keep me out of the market. I'm going to just design sufficient changes, and patent attorney going to talk to patent attorney, and then the patent attorney for the design, for the person who has a design registration, is going to say, okay, yes, if you make that, then I'm now comfortable that you're out. You can make that. And they're going to talk and agree as to, so it's not going to keep the competitor out. It's just going to make sure that when the products are side by side, you know, the consumer is going to go, yeah, that is actually a different product. I want that one. But what you're really buying is a number. That's really what you're buying with a design registration. Because if you see this and a number on it, you're likely not going to copy it. That's where the value lies.
Brilliant.
Okay, Anthony, thank you very, very much. Gavin, can I hand over to you to close the meeting?
Yeah, sure. So I've already kind of sung your praises a little bit in opening to my question, but I'll sing it a bit more. I mean, it's fantastic. I mean, I know me and you go back a bit further, and what I've always liked about you, Anthony, is that you're the most unlawyer-like lawyer that I know, and that's a compliment.
Take it as a compliment, Garrett.
Because most lawyers, and particularly patent lawyers, I just, as soon as they open their mouths, I just want to roll my eyes, because all you hear is get this patented, whether it's actually should be or not, because they just see these dollar signs and they're seeing it from their perspective, and often their advice is completely wrong and anti kind of market, if so to speak, and it's the wrong advice that people should hear. And you've never given that advice. In fact, you've always given the opposite. Even tonight, amazingly, you've told everyone not to use you. You've said, go do it all yourself. Go do the search yourself, go do a provisional patent yourself, and only use me when you've got something that actually works, which 90% of the time is not going to happen. So I applaud you for that. I mean, I think it's brilliant. And you can see in the content that you provided, I mean, it's hugely informative with practical, fantastic examples of everyday products that we can relate to. You brought this marketing angle to life, which I've never seen a patent lawyer do before. Never. I mean, it's just, just really, really useful advice. And you can see, I mean, it was just like a riveting talk on patent law, which just never happens. You used to avoid patent talks like the plague, and this one was really like incredibly useful and entertaining and interesting. And thank you. We've got the recording, and it'll go up on the website, and it'll give a whole lot of other people incredibly, really useful advice that they're not going to get anywhere else. So thank you for that. Thank you for taking the time.
It's been an absolute pleasure. Thank you. Thanks for arranging. And
it's a testament, Anthony, where we've gone 30 minutes over time, and the audience is steady. So thank you very, very much.
You locked them in.
And thank you to everybody. Please, we will see you next week for Carrie Jeske. She's a product scout. She's a specialist in DRTV, and she does all sorts of interesting other things. And she'll be coming out to South Africa in April next year. So we're in for lots of treats. Stephen Key coming up on the 25th of October, and Carrie Jeske next week, and in person next year. Thank you very much, Anthony, and thank you very much for everybody. Good night.
Super. Good night, everyone. Cheers.
Thank you.